Good morning, everyone. This is Afia Sengupta from the Current Affairs Times. Corruption, fraud, and deception at its highest levels. Today, we analyze the charges on Donald Trump pertaining to the inflation of his assets. Did Donald Trump, in fact, inflate and deflate his assets for tax benefits? Why is he withholding pertinent financial information? On Monday, Letitia James, the State Attorney General of the state of New York, filed a lawsuit against Eric Trump, the Trump Organization, and its holdings. Seven Springs LLC, one of the holdings, is accused of fraud because of an easement donation that was linked to the president's tax returns. Now, the state of New York, via a motion to compel production of documents, has asked Trump's businesses to produce the thousands of documents that have been withheld and redacted over the past couple of months. These papers are extremely important because they could potentially indicate that Donald Trump, in fact, improperly inflated his assets on his financial statements. Now, it is a lot to sort out because there are nearly 500 entities that collectively form the Trump Organization. Now, the withheld financial documents include easement donation and compliance documents and many emails exchanged between engineers, attorneys, and other third parties. These papers could potentially detail U.S. Treasury regulations and commercial zoning regulations. Associates and partners of the Trump Organization, including the law firm Morgan Lewis and its partner Sherry Dillon, have been allegedly playing a very important role in these discussions and evaluations, which were not purely legal in nature, but assisted Trump in making important decisions. According to the Attorney General, this information is not privileged because it helped him make business decisions. One of the really big questions over here is whether Donald Trump actually inflated his assets, in particular, the value of an estate owned by Silver Springs LLC. Silver Springs LLC owns a golf course estate, and they have claimed an enormous amount of $21.1 million in tax deductions for donating a conservation easement on this property in 2015. Now, this property was also listed as a part of Donald Trump's personal net worth. The Trump Organization has exercised privilege over purely business records. Eric Trump further refused to comply with the Attorney General's subpoena. Initially, his attorneys were cooperating, given that these charges were civil in nature. However, they later on took back their cooperation and exercised his Fifth Amendment rights, among other executive privileges. The next and extremely important property under investigation is the Trump International Hotel and Tower in Chicago. A major loan secured by a mortgage was obtained from Fortress Credit Corporation by pledging the shares of one of Trump's entities. In 2010, Fortress agreed to reduce the outstanding principal amount of this loan along with interest. And was this forgiven loan amount disclosed in Trump's tax returns? We do not know. Furthermore, in 2012, Fortress agreed to a very heavily discounted loan prepayment of $48 million as against the actual outstanding debt of $150 million. Despite multiple subpoenas, not one single document was produced disclosing the reason behind this discount. Only privileged logs have been produced. Trump's accounting firms disclosed this information to financial institutions. However, these financial institutions withheld this information under false pretenses. Another property under investigation is 40 Wall Street, which has eventually merged into Capital One. For 40 Wall Street also, a mortgage was initially obtained, and thereafter the loan amount was reduced to as low as $160 million, $20 million of which was personally guaranteed by Donald Trump. Again, no paper trails have been produced. The accounting firm Cushman valued Trump's national golf course in Los Angeles' easement at $25 million. Now, information on these documents is extremely pertinent and important for the government, the state, and his presidency. Dozens of responsive records are being withheld. Alan Weisberg, Trump Organization's CFO denied disclosing information about his previous grand jury appearances. Attorney Charles Martin-Bano also asserted the Fifth Amendment rights against self-incrimination and refused to comply with the subpoenas pertaining to third-party communication. He, however, did testify that prior to his testimony, he reviewed documents to refresh his memory. Now, these documents that are recollection documents have also not been provided to the state of New York, even though the state is entitled to those. Now, at this point, privilege has to be construed very, very narrowly, especially since these documents are very, very important in the truth-finding process. All withheld communication here were not just for the purposes of rendering legal advice, but also many a times for rendering business advice. Again, they did not have a legal character. Major compliance documents have been withheld for months. Trump's organization initially confirmed that Alan Weisberg would testify as to the 2012 tax returns. However, Alan claims to have no relevant information nor any documents pertaining to those. He further confirmed that he did not know where on those returns were the fortress loan forgived amounts shown or indicated as income. None of the privileged documents have been identified by the defense. Only logs have been produced. Why this inconsistency? Is this a stall tactic to delay discovery?